What's next?
3031, Dr. Mendez's records.
And give me a time frame that we're talking about.
October, December of 2015, and Dr. Mendez will be testifying.
So this is around the time of Maya Kowalski's trip to Mexico.
That's correct, Your Honor.
And there has been testimony about the Lee Memorial.
Yeah, that's believed so.
Plaintiffs?
This alone is the only page?
Apparently it's 39 pages.
Right. No objection to the document other than a, quote, diagnosis, or it wasn't even that. Dr. Mendez is the one who met very briefly with the Kowalskis and then came up with the Munchausen as a possibility. That's not, and so we moved to exclude any, quote, opinion by Dr. Menendez contained within there. But the document itself, we don't have a problem with. We are just moving to exclude and redact anything having to do with a, quote, diagnosis. He had completely no qualifications whatsoever to make that.
That would seem like you can cross-examine him on.
Well, the problem is if it's taken out of context, Your Honor, then it would be, I think, a 403 issue. And so until such time as there was sufficient record, predicate in the record for the court to determine whether or not the jury should be seeing random comments by physicians who may or may not have liked Beata Kowalski and may or may not have any possible qualifications to throw these things out.
Let me ask the defense this.
Yes, sir.
I have been excluding Chapter 39 matters
Yes.
at the defense's request. Why does this not go to a Chapter 39 issue? Because we're not this. What does this go to? What cause of action does this go or defend against?
Mr. Shapiro is going to respond to that. Sorry, Your Honor.
Yes, Your Honor. This goes to confirm he is an independent treating provider that noticed irregularities between the relationship between the mother and suspecting whether this was actually CRPS or some other underlying psychological factors. That's been a very important theme for the defense to be able to say that all children saw inconsistencies and irregularities in their record, so did other providers as well. It doesn't go to Chapter 39. It goes to exactly to confirm that a lot of what all children saw was also the same. And there's an allegation in this case for medical malpractice, mistreatment, and the plaintiff saying, you know, you got this diagnosis wrong in the record, you mistreated her in the record. So this is a prior physician that made a very similar or same observation and diagnosis. So we go with that.
But assume for the sake of argument it goes to medical malpractice. How does that help the jury as to what Johns Hopkins Children's Hospital should have done or did do with respect to treating Maya Kowalski?
Well, if the court is going to exclude the plaintiff from alleging that the diagnosis of Munchausen by proxy is medical malpractice, then perhaps this doesn't come in. But if the court is going to allow the plaintiff to insinuate or argue, as I believe they've argued repeatedly, that this diagnosis of Munchausen that was on the Morse transfer is so far out of left field and you came up with this and this was wrong, you have no support for this. We have another physician who a year earlier made a very similar or same observation / diagnosis. So it goes to that exact issue. Now, if the court is going to say, I'm not going to allow this jury to consider any of the diagnoses made at all children's as part of a medical malpractice claim, then we could possibly reconsider this. But at this point, the jury's heard this. They've heard that the Kowalskis were floored by this. This came out of left field. And here we have a doctor, an independent physician, making the same observations and diagnosis. So it goes directly and as a defense to the claims that the Kowalskis have raised in their case in chief.
Is this document for purposes of today?
Pardon me?
I think I'm going to need to think about this more. I mean, obviously there's been discussion of Munchausen and by proxy as well. But I'm still trying to wrap my head around the concept of, sure, the All Children's was aware of that as a possibility, but how does that talk to us about what All Children's Hospital should have done or did do as far as its treatment of Maya Kowalski? I mean, because from a 30,000 foot view, can a medical provider say, oh, well, look, there, in this record from somebody else a year or two ago has this thing, therefore I don't have to do, I don't have to provide treatment for the patient in front of me that I've got my hands on right then and there.
That's not the argument, Your Honor. The standard of care defined under Florida law is what a reasonable health care provider would do under same or similar circumstances. So the plaintiff has introduced to this jury that part of their big defense for the reason for not consenting to the transfer is this diagnosis code that came out of nowhere. Part of the defense of that is for us to be able to tell the jury that this diagnosis that they say was the impediment was out of left field. They're saying it's out of left field. It's not part of the standard of care. For us to be able to tell the jury what would a same or similar reasonably prudent healthcare provider do, we absolutely need to be able to say same or similar healthcare physicians now in Naples, in Tampa General, at Lurie Children's made the same observations.
I feel you're misconstruing what I've heard. Maybe I misheard. But I heard the plaintiff say that they did not want to sign documents that had that diagnosis on it, and they felt that there might have even been criminal liability if they were to sign a document. So they're basically making a declaration against their own interest, which is different than what you just argued.
Right, but
so did I misunderstand the plaintiff's position?
Respectfully, I think they have said that, but they've also said to this jury that that diagnosis was incorrect. They're implying to this jury that that diagnosis came out of left field, that it wasn't made in good faith, and if Dr. Newberger specifically said it in his testimony that that was an incorrect diagnosis to the prejudice of the family. This goes directly to observations. That's our entire theme of the case, that there were other providers at the time raising these red flags and making diagnoses and observations that were exactly similar to this one.
I think I need more time on it, and I think we need to perhaps a memo on this one.
Okay, and I'll just one other thing while Your Honor is considering it. This also goes to the issue with Dr. Wassenauer. This diagnosis, suspicion of Munchausen by proxy, went back to Dr. Wassenauer as a letter to him raising this, and part of the direct and cross-examination of Dr. Wassenauer was, did you see this in the record? What did you do to intervene on this point? What did you advise the Kowalskis? It also goes to their awareness as a potential in the record of somebody else telling the Kowalskis, we suspect there's a psychological factor. Perhaps you don't need to go to Mexico. Perhaps this is not a course of treatment that is being recommended. So it's an incredibly important note to the defense for a number of different reasons.
What's next?
Well, we object, Your Honor. I think the redactions there are prejudicial, and the idea that she's doing this for financial gain is what the defense wants to get at. So there's no way to do this. Well, part of the Munchausen diagnosis or theory is that a parent's doing this for ulterior motive. So they want to argue that Beata Kowalski is putting her daughter through all of this because she can make a few $1,000s. The redactions under that last paragraph says begins currently. You can see two redactions, which would be insurance companies. And so, yeah, it's expensive, but the reason she's seeking money is because insurance doesn't cover the treatments. So I don't know how you can extract that and then make an accusation against the mother that she's doing this all for financial gain.
I just had a clarification. Are the plaintiffs alleging in this case that we misdiagnosed Munchausen or no?
Well, let me ask you this. Is the hospital contending that mom had Munchausen?
Well, the diagnosis code that we have to defend says one of the reasons for transfer, it's in the diagnosis. So It's one of the diagnoses. Are the plaintiffs alleging that that's a misdiagnosis?
Because I've been unclear as to whether the defense agrees that whether she does or does not have CRPS.
The defense of this case, from a medical malpractice standpoint, is that whether this was psychological, RSD, conversion disorder, Munchausen's by proxy, the treatment would be the same: physical therapy, cognitive therapy, occupational therapy. What I'm asking the plaintiff is the plaintiff alleging that the Munchausen diagnosis was wrong, that we committed medical malpractice by having that appear in our record, that we committed medical malpractice by having that on the transfer code, that it goes to that because of that allegation that pushed Beata to some type of intentional infliction of emotional distress. If they are, then we absolutely need not just these that I'm going to hand to court, but these things of fundraising, because it does go to that diagnosis. So the answer to Your Honor's question is, we don't plan on making this case about whether she had, which disorder they had, but we definitely, if the plaintiff is going to allege, which I think they have, clearly, that the diagnosis of Munchausen inflicted distress, stopped transfers to the Moors, was a medical malpractice diagnosis, then this would go to our defense to say that that diagnosis was one of the working diagnoses on the discharge.
Yeah, I'm unclear.
Okay.
Because I go back to opening statement, and Mr. Hunter made a statement to the jury to the effect of, we did not have to be right, we only had to be reasonable.
Correct.
Which I thought was an interesting statement at the time. But I'm unclear now by what you're saying whether the hospital agrees that Maya Kowalski has CRPS. Because, I just heard a whole bunch of depositions today that seems to suggest that the hospital is saying she doesn't have CRPS.
The hospital's position on this, and from the defense's point, is very clear. The diagnosis of CRPS is questionable. Whether she has it or not is subject to debate, because there's no test to rule it in. There's no test to rule it out. It's a syndrome. It's not like you can take a blood test and say that you have CRPS the way you could say you have leukemia. But from all children's point of view, whether she had CRPS, whether she had psychosomatic pain, conversion disorder, or whatever the new language was that you heard from the doctor, the medical treatment for this is the same: cognitive behavioral therapy, physical therapy, occupational therapy, all of which we provided, and all of which, to the extent we could not provide, we were trying to transfer to other institutions that had a higher level of care for this. Yeah, I think that you can see in the discharge, if it's on the admission diagnosis, we provided treatment for her if she would have had it. It's also on the discharge. CRPS is on the discharge diagnosis as a can't rule out. So the hospital's position on this, I don't think should not be unclear to this court or to this jury. We are not taking the position that Maya never had CRPS. It was a diagnosis that we considered, we respected, we provided treatment for, just the same as if she had a psychosomatic disorder. And on the discharge diagnosis, it says it couldn't be ruled out. So if that answers the court's specific question about what our position is on CRPS. There's just not a blood test for this that we can say yes, she had it, or no, she had it.
I heard what you're saying. I'm not sure I think it's a clear answer, but I hear and I appreciate the line you seem to be trying to walk, but I'm not sure I totally understand it being a clear answer.
I'll try to give it to you in 10 seconds. To the pain management team, it didn't matter. The treatment and Dr. Elliott has testified to this. Our pain management team testified to it. I think the ICU doctors, I thought, testified to it, but our pain management people will testify to this. The treatment for RSD/CRPS is exactly the same treatment as cognitive behavior, as conversion disorder or any psychosomatic, or I think it was called central sensitization disease. It's cognitive, physical, occupational therapy. And to the all children's team, it didn't matter whether she had CRPS or not.
Well, then my question back is, does it matter whether mom had Munchausen? Because one, Johns Hopkins All Children's Hospital has taken the position that it's in a children's hospital, it's not an adult hospital. It did not seek to provide any care and treatment. There's certainly evidence that's been adduced that this is a diagnosis that would impact Viata. Frankly, I'm struggling to see how it goes to what type of care for CRPS that the hospital did or did not provide to Maya, and the focus is on Maya for medical malpractice. So that, I'm struggling with why we're spending so much time on it when it doesn't seem to be an actual issue in the case.
Only because the plaintiff has injected this into the case, saying that your diagnosis of Munchausen by proxy or as a reason for the transfer is the reason we couldn't accept the transfer, and it was a negligent diagnosis. Your diagnosis of Munchausen by proxy caused intentional...
Time. Correct me if I'm wrong, but I don't think the basis of medical malpractice is the diagnosis that precluded a transfer. Is that, am I misunderstanding the case?
That specific question, whether the listing of Munchausen by proxy on a transfer diagnosis is not the basis for a malpractice claim, that was first an issue raised in this case by the defense when they attempted to claim that effectively Jack and Beata had been unreasonable for not accepting that psychiatric diagnosis in that transfer, and it was on them for not accepting the transfer to Nemours. Then we get testimony that Nemours doesn't in fact have a CRPS inpatient program, and Ms. Beatty lied on the phone to Beata Kowalski, and it was a psychiatric diagnosis they were trying to transfer her for.
Let me stop you because I need to understand. Is the plaintiff saying that there was negligence on the part of the hospital having to do with having that diagnosis, the conversion / Munchausen, as a medical negligence on failure to transfer?
I just want to rephrase the question to make sure I'm understanding. Is our position that it was a breach of the standard of care to use Munchausen in the transfer diagnosis? Am I understanding that correctly?
Are you claiming any sort of damages? Let's do it this way.
Sure.
Any sort of damages associated with a non-transfer that occurred on whatever date that was or that time period?
When was the Nemours transfer?
There was two attempts, right?
It was in November, and I would only, if I may, Your Honor, I would even broaden that to ask the plaintiff, are they seeking any damages from this defense for the diagnosis of Munchausen by proxy? If they're not, that may simplify what Your Honor's concern is.
Well, I'm going to try to answer the court's question first. I don't believe we're allowed to seek damages from the transfer attempt in the context of a Chapter 39 proceeding. I think that was a defense theory raised to muddy up the false imprisonment claim, and now I'm hearing that this transfer diagnosis or transfer attempt wasn't even made until the middle of the dependency proceeding when Chapter 39 shelter order was in place. So, I'm sorry.
No, go ahead.
With respect to Munchausen by proxy, I think the court a second ago spotted the issue, which is that's a diagnosis of the mom. So they take a position that's duplicitous. That is in their records, Munchausen by proxy, there's no question. But then they retreat and say, well, we're a pediatric hospital, we can't treat or diagnose adults. But yet their records of Maya Kowalski are littered with an adult diagnosis. We have been asking the question for years, and this is what you're hearing. We can't even get a frank admission as to whether or not CRPS was or was not a diagnosis of the hospital they were treating. We've tried innumerable times. They won't commit to what their diagnosis was. And then to take the position that the treatments for all of these conditions are identical, well, that's preposterous. But secondly, if that's true, our breach of standard of care, Dr. Duncan testified to this. If you're taking the position that all of these conditions, no matter what they are, require cognitive behavioral therapy, and you provide 3 hours of cognitive behavioral therapy over the course of a 3.5-month admission, we can go with that for the moment, and it's a breach of the standard of care no matter what diagnosis they ultimately land on, but they won't land on one.
Well, with respect to the first attempt transfer, the one in October that occurred during the period of time for the claim of false imprisonment, it seems to me whether mom had Munchausen or not is not the issue. Because the evidence, the issue is mom didn't want to sign the form because of that diagnosis. So even if the plaintiffs, or even if the defense said, well, mom had Munchausen, that doesn't change the fact that mom wasn't going to sign the form. And so that doesn't go to the question of false imprisonment.
Right. The form was
so how does it go to Maya's medical malpractice claim or any claim that's actually remaining in this case?
Okay. To correct, that transfer attempt was in November, but I would just reiterate this.
The first one was October.
The first one was off, but the form was for a November transfer.
Okay.
But all that being said, I think I see exactly what the court's question is, so I would ask it again. Are the plaintiffs seeking damages from my client for any of the counts for what they're alleging is a miss or a false diagnosis of Munchausen by proxy? If they're not, if we have a stipulation from the plaintiff, we're not seeking damages from you for the diagnosis of Munchausen by proxy, then I don't have to put on a case about why that diagnosis was correct. So I turn to the plaintiff and ask him that again.
What I want is I want the defense team to huddle inclusive of Mr. Hunter and the plaintiff's team to huddle inclusive of Mr. Anderson. I want to begin today, or I guess our next issue today, since we already had a first issue, is to pick up where we were discussing at the end of the day on Friday, which I thought was a very illuminating discussion, but certainly Mr. Anderson and Mr. Hunter weren't in the room. I'm hoping each side has had an opportunity to discuss amongst the individual teams and hopefully with each other the issue that were discussed, i.e. Whether there was going to be a claim for damages associated with Munchausen by proxy from the plaintiffs, and whether the defense had some further statement or clarification as to whether it was contending or not contending that. So, who's going to lead us off in this little discussion?
Since I was on the spot on Friday, I will. We filed last night a memorandum in response. I have a paper copy here for the court.
Is this the one about basically moving to conform the pleadings if we start talking about Munchausen by proxy?
As alternative relief, yes, Your Honor. So
I have read that one.
Okay, well then, I'll be succinct. Our position is we are not currently seeking damages for the diagnosis or mere suspicion of Munchausen by proxy. We attempted to do so. That claim was brought for Beata Kowalski in our count 17 for medical malpractice. The defense filed a motion for summary judgment. They prevailed, arguing that they had made no such diagnosis. She was never a patient. Their licensure prevents them from treating or evaluating people older than 22, and that Munchausen by proxy, if it appeared in the records, was a mere suspicion. So for all those reasons, we are not and have not sought damages in this case for Munchausen by proxy. None of our psychiatric experts testified to anything relevant to Munchausen by proxy, the diagnostic criteria, anything of the sort. So we object to the admission of evidence at this point of Munchausen by proxy or documents aimed at shoring up suspicions of Munchausen by proxy. If the defense prevails on this argument, then we do move to reassert count 17 and move forward with a medical malpractice claim for Beata Kowalski.
Please, the court. I'll take these in order if you wish. The first thing I heard was a question of our position with respect to the question of whether there is CRPS here. I'll address that first. Our position is and has been that Maya Kowalski does not have CRPS, that she has a psychogenic disorder of some sort, and that is what we suspected at the time of hospitalization, and that is what we had charted throughout the hospitalization. Throughout the hospitalization, however, we never ruled out CRPS. It cannot be definitively ruled out. As a matter of fact, I'm sure you'll hear one of our experts cross-examine tomorrow with an observation in his report that while he does not believe that she had CRPS, it cannot be definitively ruled out, or at least reasonable minds can differ with respect to that. The point here is, however, and has been, that the treatment rendered for the purported CRPS was inappropriate. That was suspected at the time of hospitalization, and that is our position to this day. The point here is that this patient had a pain syndrome of some sort, and whether it was CRPS or whether she was a victim of Munchausen by proxy and or had conversion disorder or some other psychogenic pain syndrome, the point remains that the treatment for those conditions is the same. The standard of care treatment for those conditions is the same. Whether it's CRPS, a pain syndrome associated with Munchausen's, or conversion disorder, or some derivation of the two or three, the treatment is all the same. That's where we are coming from. That's where we've been. Now, as far as the Munchausen's by proxy is concerned, I would direct Your Honor's attention to what plaintiffs have indicated is the 8th amended complaint. In paragraphs 27 and 28, there is an express allegation that we were remiss in diagnosing Maya with a variety of psychiatric conditions and alleging that none of them were treated. There's also an allegation that with reference to Munchausen by proxy in that same paragraph, and another in paragraph 130. In opening statement, counsel indicated that the plaintiffs were going to prove that the allegations that Beata Kowalski was trying to harm her children, both Kyle and MK, caused her in the end to, quote, lose control of the maternal instinct and resulted in suicide, unquote. There are multiple other references in opening statement to the same type of allegation. The allegation that Beata was wrongfully accused of Munchausen's or of attempting to harm her children or taking inappropriate care of her children goes to the heart of plaintiff's allegations of intentional infliction of emotional distress. The point that is being made throughout here, we think, by the plaintiffs, is that these allegations against the defendant, are the soul of the case. They can't run from that, Your Honor. And preventing us at this point from proving up, as we intend to do today and tomorrow, that Munchausen's was a reasonable suspicion, if not the correct diagnosis, goes to the heart of the defense.
But the diagnosis goes to mom and not to Maya.
That is correct, Your Honor, but it's material to Maya for this reason. Munchausen by proxy may well be, and probably is, an adult diagnosis. It's a diagnosis of the perpetrator. But we have to treat the victim. Maya has Munchausen by proxy. The point is that she's a victim of Munchausen by proxy and or a conversion disorder that is associated with it. That was what was thought at the time. That is what we think today. The question of whether there is a diagnosis of Maya personally, her individually, with Munchausen by proxy is a red herring. The point is that syndrome, we believe there was reasonable cause to suspect and conclude existed, and that it was influencing what was happening and being exhibited in behavior by Maya. That's the point.
And what were the specific allegations in the Eighth Amendment complaint that you referenced?
In paragraph 128, let me make sure I get them all here, Jeff. While Maya, under paragraph 128, while Maya was under its care, JHACH failed to develop a coherent treatment plan for Maya, with its doctors and staff consistently denying Maya's CRPS diagnosis and instead diagnosing Maya with a variety of psychiatric conditions, none of which were treated. Even when advised by pain physicians at other medical institutions that JHACH's approach and diagnosis were inconsistent and mutually exclusive, JHACH failed to correct its approach to Maya's care. In early January, as JHACH was hell-bent on painting Maya as a psychiatric patient while still maintaining to the dependency court that she was a victim of Munchausen by proxy, a physician at Kennedy Krieger grew frustrated with the management team and physicians during a call and advised that, quote, Munchausen and conversion are competing disorders and JHACH needs to pick one. That this did not occur to JHACH as they persisted in their unsound approach is a breach of the highest order. Now that,
So I asked what paragraph cite. Can you just tell me what paragraph?
I'm sorry, yes, that's paragraph 128 I just read. Sorry.
Okay, no worries. I just want to know so I can go back and read for myself.
Okay, sorry.
So just tell me whatever specific allegations that you want me to look at.
And you might also consult paragraph 129 and 130, as well as paragraph 131 and 132. Now that's in the operative Eighth Amendment complaint. If you refer to the opening statement, you will see the passage that I just referred to, as well as a number of others. We did a word search over the weekend of the plaintiff's transcripts that we have thus far. It's not all of them. We see 64 references to Munchausen's by proxy in the plaintiff's case. The idea, the central point here, the overarching allegations, as I understand them to be, and as the defense has developed its case, are essentially twofold. Number one, there is an allegation that we failed to appreciate and honor, if you will, a diagnosis of CRPS that this patient had received from essentially 2, if not 3, outpatient physicians. We were alleged to have been negligent in not recognizing that diagnosis, accepting that diagnosis, and continuing the care of that diagnosis as had been outlined by Drs. Kirkpatrick, Cantu, and Hannah, which that we believed to have been destructive and dangerous. But the allegation is that we failed to proceed with treating her in accordance with that diagnosis and that treatment plan. The secondary allegation is that instead of doing that, we suspected a psychogenic component to her presentation. We suspected a psychogenic component to the way in which she was presenting her pain syndrome, as did, by our count, approximately 40 other physicians at 2 other institutions at Lurie Children's and Tampa General, that we suspected that there was Munchausen's by proxy and or conversion disorder and or factitious disorder, depending upon which of those you subscribe to. And there's a good deal of controversy about them that Your Honor is about to hear a good bit more about. But the point is that the soul of their allegation against us is that we suspected the psychogenic constellation of presentation symptoms, and that was a deviation from the standard of care in the way we pursued that and allegedly failed to properly treat it.
Let me attempt to articulate some thoughts I had that I've been spending over the weekend trying to coalesce. into something hopefully articulable. Assume for the sake of argument, mom had Munchausen or whatever of those terms you wish to apply. So just assume that to be true. Does that change anything with respect to how the hospital should be treating its patient, who is not the mom, but Maya? And I just as, let me back up. The question of whether mom has Munchausen, to me, sounds like something that would have been front and center in the dependency court on the medical neglect, medical abuse case. In the dependency court, of course, that we're not trying the Chapter 39 aspect in this case. Just like the jury knows that DCF was involved and there was a dependency court, it knows that the position of Johns Hopkins, All Children's Hospital, was that mom had this. But in this lawsuit, do we need to prove whether mom had it or not? And that's what I continue to struggle with, because it doesn't seem to me that it really goes to your medical malpractice case. And I was thinking over the weekend, like, well, does it go to your defense of the intentional infliction of emotional distress count? And obviously, I think the concept that you believed that to be the case, that mom did have it, I think is relevant. But at what point do we need to keep going on and on and on and trying to prove mom has Munchausen? Because even if that's true, how does that change what was done or not done to Maya in this case? Now, I think you've got some traction with me in the intentional infliction count, but what started all this is a whole series of emails and possible blogs about what was going on with Maya that doesn't seem to have anything to do with medical malpractice. But perhaps it does with intentional infliction. That's kind of the dichotomy. So if you'd like to comment on my rumblings there, I'll give you a chance. Because ultimately I need to make decisions on admission of evidence.
I understand, Judge. I'm kind of flabbergasted.
Can I make one comment as the person who understands the DCF part of this?
Well, once I do that, Mr. Altenburn, then I'm opening up, and I was trying to keep us more focused on proceeding forward. Mr. Hunter.
Let me start by noting that based upon Your Honor's rulings, this is not just a medical malpractice case. A lot of it is a medical malpractice case, no question. But it's a battery case, it's a false imprisonment case, it's a negligent infliction of emotional distress case, it's an intentional infliction of emotional distress case. Over and over and over again, we have heard from the plaintiffs this evidence sponsored, that evidence admitted on the basis that it went to the plaintiff's or the decedent's state of mind. The decedent's state of mind is what caused, allegedly, her to commit suicide. Her state of mind was created, allegedly, by what? By her daughter's disease? Probably. But the allegation against us is that we created her state of mind. And we created her state of mind by doing as was suggested in opening, and that is that we were suggesting that her actions and her approach to her child's disease was harming the child. We're accused, they, that includes we, and there's been confabulation about that. We, are accused of separating the child from the mother. Why? Because of the allegation that the mother was doing harm to her child. That allegation is based around Munchausen by proxy. The defense of this case, with all respect, Your Honor, whether it's malpractice, whether it's false imprisonment, whether it's any of these things, all of the defense of this case rests upon the proposition that the pattern and practice of therapeutic and maternal behavior here was dangerous and inappropriate to this child. And that is why reports were made. And that is why suspicions were hatched. And that is why we attempted to act as we did with respect to the discharge of the child or the lack thereof and the circumstances under which we attempted to treat her and to transfer her elsewhere for more treatment in accordance with the standard of care. But we cannot defend our case, Your Honor, without the idea being a centerpiece that it was reasonable for us to suspect that there was a Munchausen by proxy or a factitious disorder by proxy going on here, and that we were reasonable in suspecting that, and that we were reasonable in acting upon that as we did and attempting to treat this patient as we did. That is central to the defense of the case. If you emasculate that, you've emasculated our defense. And I don't know what I can tell you beyond that. What you're going to hear today is from a witness who months before we ever saw this patient suspected the same thing. We believe that to be directly relevant to what we did, what we suspected, and how we did it. You're going to hear from our treating physician, Dr. Elliott, one of our employees, about what he encountered, how he responded, what he did. You're going to hear from an expert tomorrow that will pull all of this together, we hope. But I have to tell you, Your Honor, this is inimical and central to what they've alleged against us and to our defense against it.
Let me hear from Mr. White, and I will tell you what I'm hearing about, at least with respect to the intentional infliction of emotional distress count, that there may be some need for some of the evidence that was being discussed on Friday afternoon. So, Mr. Whitney, let me hear from you, and then we'll move on.
Well, I'll start there with the intentional infliction of emotional distress. The contours of the hospital's conduct and Ms. Kowalski's conduct and what was not allowable and what was allowable with respect to her visitation or their supervision all goes to Chapter 39. So what we've brought forward on intentional infliction are things that have nothing to do with Munchausen by proxy. Catherine Beatty sitting in on phone calls. Catherine Beatty telling Jack to divorce his wife. Catherine Beatty saying that she's going to adopt Maya and be her mother. None of these things have to do with Munchausen by proxy. Listening to Mr. Hunter, the phrases that he uses give away that the Munchausen by proxy is wedded to Chapter 39 proceedings. He talks about justifying the separation. Justifying the separation is what they were doing in the dependency court. And those orders separated the mother and child, but there's no need to justify the separation unless we're going to relitigate the Chapter 39 proceeding. He talks about suspicions. He talks about reports, hotline reports. These all go straight to Chapter 39. Even the allegations he points to in our medical malpractice claim, in paragraph 128, Munchausen and conversion are competing disorders. When we tried to introduce that note out of the risk management file, it was excluded because it was central to Chapter 39. in paragraph 130, the mention of Nurse Ashley stating that Maya exhibited textbook Munchausen. Yes, that's in our claim, but the court's been drawing lines, and one of the lines it's drawn is that the hotline reports are out. Nurse Ashley's characterization as textbook Munchausen is in the first or the second hotline call. That's not part of this case. The defense, even if the defense was allowed to put in all of this evidence, they can't close the loop. They have no expert on causation. They have no expert on it. They don't have an adult psychiatrist. They would need an adult psychiatrist. There's no dispute about this. The DSM-5 says the perpetrator receives this diagnosis. It's the adult. They would need an adult psychiatrist to come in here to close the loop. The context of 64 references to Munchausen by proxy in our case. There's no specific citation, and I did not review the transcripts that they have. But the court will call the Munchausen by proxy term is what was thrown around in that transfer diagnosis to Nemours in the midst of the dependency proceeding. So I'm willing to wager that 95% plus of those references to Munchausen by proxy are specific discussions around that transfer diagnosis and the reasons that Jack and Beata declined transfer under those circumstances. Nothing about our experts getting on the stand and making arguments or opinions about whether Munchausen by proxy was or was not the appropriate diagnosis. And lastly, on the psychogenic constellation of Maya Kowalski. The psychogenic constellation of diagnoses of Maya Kowalski does not include Munchausen by proxy. It cannot. The psychogenic constellation of Maya Kowalski has to do with what their psychologist diagnosed, Dr. Katzenstein, who I think we hear from today, psychological factors affecting other medical conditions. That's the DSM-5 diagnosis of Maya Kowalski, confirming that she has CRPS, but she has a psychogenic overlay on that. The other diagnoses they entertained for Maya Kowalski in this psychogenic constellation are factitious disorder, not factitious disorder imposed on another, but factitious disorder of Maya Kowalski, and conversion disorder. So there are at least 3 diagnoses of Maya Kowalski that they threw around that compose this psychogenic constellation. None of them are Munchausen by proxy. They go specifically to Beata. So again, if Mr. Hunter's argument persuades this court, we move to reassert count 17, because now they're claiming they did make a diagnosis of Munchausen by proxy. They want to argue all about it, and so we want Beata Kowalski's medical malpractice claim back.
One other point.
Are there other issues, because it's getting close to 9 o'clock, other issues that we have to address before we bring in this jury?
I don't believe so, Judge. I just point out that as counsel just made reference to, an inimical point of the false imprisonment claim is the fact that there was a transfer offered, there was a transfer that was put together, you're going to hear more about it tomorrow morning, and it was refused. Why was it refused? Because of that diagnosis. Because of the diagnosis. Because, to almost directly quote, we would be admitting to Munchausen by proxy, to child abuse, if we signed off on those transfer papers. They put this in the case from day one, Judge, and they can't run from it now.
But okay, how does you proving that Maya did or did not have it change Beata's state of mind as to her decision not to sign the transfers concerning or when there was any sort of possible reference? And I think, though, that came later as opposed to the October date.
Yes.
Correct.
So, let's try not to conflate those. I'm having enough trouble keeping those two apart in my mind myself. But, I feel like I've clipped the plaintiff's wings very hard on trying to keep Chapter 39 out. And it just seems that now that I've done that, the defense wants to make this case in trying to prove that Beata had Munchausen, which seems to be the heart of what was going to be in the dependency court, which is what I was not letting in the plaintiff's case in chief.
with all respect, Your Honor, you have ruled on the Chapter 39, and to be honest with you, I have yet to understand where the dividing line is on this. But what I do know is this. What I do know is that the remaining case against us, whether it's the false imprisonment or the intentional infliction or the negligent infliction of the malpractice, is all bound up in in what we suspected and what we did and how we ruled on it, and the impact of that on Mrs. Kowalski's state of mind and on her conduct. And that's, I mean, if Your Honor tries to carve that out of this case, it eviscerates a major portion of the defense and puts us in a completely untenable position. I would suggest to the court that Mr. Whitney's argument is for the jury. It's not for admissibility. And I would urge Your Honor to let this go forward and let us try our case.
Are there other issues that we have to address prior to the jury coming in?
Well, Judge, the first witness is on this issue.
On Beata's, whether she has?
No, Judge, the first witness is Dr. Elvin Mendez of Fort Myers. Dr. Mendez saw this patient in October of 2015 and December of 2015. He was consulted regarding immunotherapy, and after 2 visits with this patient, he indicated in one of his conclusions that Munchausen by proxy should be considered, and he advised Dr. Wasenauer of that fact in a copy of a letter to him. The point of his testimony is exactly this, and the point of his testimony is, frankly, a point I thought I tried to make an opening, and that is that we stumbled upon this trail and followed it. It was not a new trail.
Mr. Altenberg.
2 completely unrelated things.
And Mr. Whitney, anything else?
Well, 2 things. On Beata's state of mind and the relevance, the state of mind of Beata Kowalski that's at issue in this case is the irresistible impulse, effectively. And I would point the court back to their motion for summary judgment, again on count 17 at DIN 1933, in which they made a big point of pointing out that she was admitted to Sarasota Memorial Hospital the day of the dependency proceeding when she fainted in court, and that at that time she denied ideation, and that as of that date she did not have ideation. So her state of mind deteriorated over those next 3 months, irrelevant and irrespective of what Dr. Mendez may have thought in October of 2015. I think we need to argue this Dr. Mendez issue.
Well, I think with Dr. Mendez, I'm going to be consistent with what I did with the prior treaters that saw Maya prior to the admission to Johns Hopkins All Children's Hospital, and kind of let that type of testimony in, because it does set the stage as to how Maya presented at Johns Hopkins All Children's Hospital in October of 2016. So I think the historical stuff, at least I'm going to continue to rule like I did with the Lurie's doctor and the Tampa General Hospital doctor. I'm just going to stay consistent. If I'm going to change how I'm doing something, I'll let you know. But for now, I'm going to remain consistent as to how I ruled with respect to those 2 hospital visits.
May I make a record on that?
Sure.
Well, we believe, again, this is Chapter 39, issue 403, and irrelevant to the claims in this case. I'll point out again, at the time Maya Kowalski was hospitalized at Johns Hopkins All Children's Hospital during the false imprisonment first week, they did not have any knowledge of Dr. Mendez's records.
I don't think it's going to false imprisonment. I mean, I know it's been banning about, but I don't see how it goes to false imprisonment. I am, frankly, the only place it really seems that it possibly fits is the intentional infliction count. I still don't understand how it would fit with medical malpractice with respect to Maya.
All right.
But, I mean, I do think and I do have some belief it does go to the defense of your IIED count.
Understood. We disagree, but we understand.
Okay. So are we ready to bring in the jury?
We have another expert whose name is Alexander, who is a board-certified pediatrician. He's also board-certified in child abuse pediatrics. His principal purpose is to testify about general pediatrics, and once we get straightened out where we can go with it, what Dr. Smith did. The baseline of his opinion has to do, again, with child abuse pediatrics and Dr. Smith's involvement in the case, as well as the standard of care for pediatricians. He's not testifying about Fabry issues or criticizing other doctors. He's just testifying about standard of practice, whether it was reasonable to suspect Munchausen by proxy, whether it was reasonable to suspect factitious disorder and conversion disorder in this patient, and he's qualified to do all the above. The counsel, I think, is also concerned about Dr. Kelly. I've told him he's not coming. There are not any other witnesses that I think we need to cover at this time.
Maybe. What would you rather talk about
So I'm not sure what you're asking me to do.
I'm not asking you to do anything, Judge. I'm asking you to let us go home. If anything.
Let's second that. Let's rally.
Yeah, Judge, we'll,
Judge, I guess it would be then our motion, and the problem that we've got is exactly what the court has been dealing with over the whole weekend. They're going to try to drag this case back into a Chapter 39 debate about Munchausen by proxy for Beata Kowalski, as opposed to anything having to do with the treatment of Maya Kowalski. And the court's made that very clear, I think. So
What's the hospital's position on CRPS and what's the plaintiff's position on Munchausen? Mr. Hunter and I are presenting Dr. Alexander tomorrow, who is the counter to Dr. Newberger. And we just want to triple check because it's our last chance to get a child abuse pediatrician on the stand. We understand the plaintiff is not arguing that all children's hospital caused any element of damage in this case, any element of damage, or that the plaintiff is seeking damage from the diagnosis or suspicion of Munchausen. That's true, correct? So I would be able to say in closing argument to the jury, the plaintiff in this case is not seeking damage from All Children's Hospital and are not alleging that All Children's Hospital's suspicion or diagnosis of Munchausen in this record is a cause of damage. Is that true?
That's an accurate representation of our position. The closing argument there is phrased to even argue that it wades into Chapter 39. The instruction does the work. There was a reasonable suspicion. The court has ruled on that. We don't need to discuss it.
Because they said an opening argument, we will prove that there are false allegations of Munchausen robbed Mrs. Kowalski of her maternal instinct and caused her to commit suicide. We are running out of witnesses that could rebut that and that could be able to say to this jury that diagnosis or that suspicion was reasonable based on the evidence. We know where the court is on this. We believe we need to rebut this, but we understand that the court's ruling is they don't want to talk about Munchausen. I just don't want to be in a situation where in closing argument, they're saying that this diagnosis stopped the transfer, caused her to be distraught, and that we can tell this jury they are not seeking damages or alleging that the diagnosis of Munchausen caused or contributed damages. If that's true, then we can limit Dr. Alexander to some limited topics. We just need to make sure they're not alleging that that's an issue for this court because they put a ton of evidence in front of this jury on the Munchausen issue leading up to Your Honor's ruling.
I think both sides have refined their positions since opening statements.
Okay. And so you are affirming again what Mr. Shapiro just said.
Yes, Your Honor. And to respond to that, however, if they stand up in closing argument and make another big deal about the effort to discharge to Nemours and transfer to Nemours, then we need to be free to stand up in rebuttal and remind them that they weren't willing to do that because it was a psychiatric diagnosis. That's it.
Well, to me, what Mrs. Kowalski believed has nothing to do with us proving or not proving whether she had Munchausen in this case, which is the subject of the dependency action. I don't see how those two are the same thing. Does that change your position?
No,
Mr.
I mean,
Shapiro?
it's just the fear from the defense. Again, they said 5 times in opening argument they were seeking damages from us for the negligent diagnosis of Munchausen's, the accusations of Munchausen's. That this would be our last expert that could come in and say that that suspicion was reasonable. We're being foreclosed from this because the plaintiff, from what I can understand through Mr. Whitney, to his credit, has made clear they are not going to argue that that diagnosis was incorrect. They're not going to seek damages for it. They're not going to tell this jury that because of that diagnosis or suspicion that that either caused or contributed any damages sought by the Kowalski. But by the Kowalskis, certainly we'll have our ears open for that in closing, because if they do, we would consider that prejudicial.